Come on in, don't be shy, don't stall. We got a funky vibe, yeah. Welcome all, it's a safe spot where the truth of mine. Share your thoughts, leave your worries behind. Woo! Defenseless, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be. Woo! Got mysteries, stories, good and right. We dig deep, ain't no secrets to hide. No judgment here, just an open crew. We're all about justice and the honest view. Yeah, defenseless, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be.
Join the family you're meant to be. Do. Well, g'day. Fancy meeting you here. We have to stop meeting like this. No, we don't. Welcome. If this is your first time here, welcome to the Defence Rest. Hello, Christine. How are you, sweetheart? Lovely to see you. How are you? You good? Yeah, sorry. Welcome to the Defence Rest. It's your first time here. You're in for a treat. If it's your second or subsequent visit here, then suffer in your jocks, because you know what you're in for, and you have just wiped all future potential mental health issues, claims against the channel clean. You chose, you came, you saw, and where the rabbit hole takes us is where we go. So I've sort of got a bit of a mishmash tonight. Because I'm in Melbourne, and I wanted to cover the Karen Reid civil hearing live. Dingbat here got the time zones wrong completely, and realised when I woke up this morning that it was live this morning. Yep. So we're going to do a recap. I'm sure you've all seen most of it, if not all of it. I'm not going to play all of it. I'm just going to play the main bits, the interesting bits, and what's to come. And then we have a little case that was actually went to trial over when the actual second trial for Karen Reid was running. So it's a little case. The defendant's name is Justin Mon. And it didn't get live streamed, so I have an overview of the actual trial and what happened, and I will tell the story. He is the gentleman that shot his father and then proceeded to decapitate him and make a YouTube video out of it. Yeah. Nice bloke. So we'll be doing that one as well, which won't take long. And also, you've probably all heard about her as well. I can't find a great deal of information on her, but KELSEY FITZSIMMONS. KELSEY FITZSIMMONS was a Boston police officer who basically got postpartum depression when she had her baby, and the father of the baby daddy, filed a restraining order against her because he didn't think that the baby was safe, basically, because she was too unstable. So when the officers came to serve her the warrant, and I think these were her fellow officers as well, she reacted in a hostile manner and apparently was armed and ended up getting shot in the chest. She recovered. She went to hospital, but she's out on bond with specific conditions to have. Well, they've actually got it wrong. She hasn't got a scram monitor on because that's the ankle monitor. She has called a sober blow or something like that, where she has to actually blow into a machine to have her BAC read on random occasions. And because of her chest, hello, sweetheart, how you doing? Because of the chest injuries she sustained from the gunshot wound, she had 2 collapsed lungs, basically. She was having difficulty getting the full volume of breath into this device. And so the attorney who's representing her is actually Timothy Bradel, who is Aidan Carney's attorney as well. So he's requested a hearing to have just the device altered. So they could have used the scram ankle monitor. They could have used blood testing. They could have used urine sampling. If it weren't for the particular judge. But we'll go into that after. So we're trying to tackle 3 things. If we can, we will fit all 3 in. As I said, I'm just going to do the recap of this civil hearing. So basically, the O'Keefe family have brought charges against Karen Reid for wrongful death. And what's interesting is that I'll actually play this for you because half of the courtroom is actually Karen's legal team, which I found amusing. Rogue here. All right, let's have a quick look. Hello, sweetheart. How you doing? Did you get all your yard work done? All right. Have you all seen this hearing? I'm just laughing at how many people are representing Karen. Tell me if you can hear it.
All right.
Oh, is it?
Good afternoon, folks. Good
afternoon,
Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you state the party you represent as well, thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon. Good afternoon.
Yeah, listen to this.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reid.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defending Karen Reid.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reid.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reid.
Next minute. It's 2026.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reid.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reid.
Good afternoon, Your Honor. Marissa Paladini on behalf of Karen Reid.
Good afternoon.
Still going.
David Hassett on behalf of O'Hara Grill.
Okay. I'm sorry, I should say the waterfall.
Honey.
Get it. Good afternoon.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial.
He's very, very matter of fact, this judge. I don't mind that. That's good. No bullshit, pretty much. But yeah, yeah, we'll see how it progresses. Karen has what? It's a cult now, is it? It's not just a free Karen Reid movement. It's a cult.
date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are
attorney either.
is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with
I don't like mamby-pamby.
the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of deposition.
Only
All I can hear is where. Call ambulance. All right, let's get to the real shit. Let's get to the what they're calling a surprise announcement. The surprise is only to the court, to the plaintiffs and the judge, not a surprise to anyone else. Jay. Right. Play.
With you, Attorney Seligson?
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights, conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who are the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are
Another
in the
boring.
process of completing written discovery propounded to us from the plaintiff order extension
Back to the
until next
plaintiff.
month. We anticipate that that will be completed then. We as well.
When you say
Where Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural
Which they don't need to do.
proposal. So Mr. Diller is not being surprised by.
They don't actually have to ask for permission to write a motion, but he is asking for it anyway. And basically the reason they want to do this is because they're going to serve them anyway, and it will be the same people having the same depositions with the same witnesses, same everything, but in another separate hearing. And what they're trying to do is bring them together so that they will have the one deposition each, and it will save the court a lot more time moving forward. It will extend the length of this time of this case, but overall it saves the court having two identical hearings, one from the defendant and one from the plaintiff.
The argument that we're going to present to the court, you'll have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defense have filed motions to dismiss portions of those. So with this, at its essence, is a wrongful death action being brought by the plaintiffs,
Not
right?
justifying
So what you're seeking to
wrongful
do is
death
to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to.
Is that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. We'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct? There's 5 for the plaintiff and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this.
She didn't hit him with the car. That was proven. She didn't hit him.
Case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend depending on what the circumstances. We were charging the jury on a homicide case earlier today, so we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct?
So it's not an affirmative defense. It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts.
I don't understand how they can actually bring wrongful death claims against her when she's been proven not guilty. Like, and even the prosecution when he was telling, like doing his opening statement type of thing, he made all these claims about stuff that was proved in the trial. Like, I don't get it. I don't understand how they can actually do that now that she has been acquitted. I don't get it.
That the affirmative claims would be seeking to...
Sorry, in saying that, apparently this civil case will take 2 to 3 years before it's finished.
Seeking to be pursued
against. It's a long haul.
So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reid is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation
That's
where
right.
we consolidate them at the same time.
That's right. They did not find her guilty because there wasn't enough evidence. Even when that evidence was manipulated and tried to be misled and completely misrepresented, they still couldn't find any evidence against her. Not guilty.
That's what we're trying to suggest, maybe a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide-ranging as they just announced, then there's no way that we would not be prejudiced by their strategy.
Is that preponderance of the evidence, is that higher than beyond reasonable doubt or lower? I think it's lower, isn't it?
Plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. The cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reid had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not...
This is about when she leaves 34 Fairview, she goes back to John's place, and then she wakes Kaylee up when she gets up at 4:30 and John's not home, and she has to wake her up to get Jen's phone number from her phone. So she gets KELSEY to ring Jen McCabe for her. And that's what they're talking about here. So that the prosecution have to prove that Karen intentionally wanted to inflict emotional harm and whatever they're charged with. At that time, it was intentional to inflict that harm against her, And then for every claim that they're making, so what he's saying is that the parties didn't roll up and see John on the land, on the front nature strip. They saw him at the hospital hours later. So that was when they are saying that their emotional distress began. And they have to prove that Karen was intentionally trying to achieve that at that time. But what I don't understand is they've gone in to view their brother, and yes, it's an absolute fucking tragedy. It's revolting. But that doesn't mean every person who loses a loved one can claim wrongful death lawsuits, especially after the person has been acquitted of the charges. So I really don't know. I don't think they're going to get particularly far, but I suppose it's worth a shot for them. They feel like justice hasn't been served, and yeah, hopefully, if nothing else, because everything's back on the table now, every one of them, every one of those witnesses called, has to testify again, and who knows? Maybe they'll get more to the truth. Maybe Higgy turns. Who knows? Who knows? Because no one is off the table. They can call anyone they want
At the scene. And the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least it's played in the complaint, that will satisfy the limitations that the case law sets out, the temporal, spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother. Again,
what's the rapture? What's the rapture? I don't know what the rapture is.
they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates.
Oh, you've got no idea. Like I very, very rarely go on Facebook. I hate social media. And even here on YouTube, I really only search stuff that I'm researching. I don't go searching for crap. And if I'm on X, I basically post something to X and then piss off. I cannot be bothered in the bullshit. Don't get involved in it. But I went on Facebook to look at see if I could get some photos, screenshots from photos of my girlfriend's daughter, Mackenzie, who passed away last week, because her funeral service is on Monday. And I thought I might do like a tribute with some photos and stuff. And I've screenshotted all of that. Her school have done a tribute. Her netball club have done a tribute. And I thought that might be nice just as a presentation. And then all of the comments can like float up as the presentation is going. You know what I mean? To acknowledge that, just as a bit of a keepsake for the family. So I went onto Facebook. The first thing that popped up was my goddamn brother. Like, oh, give me strength. Give me strength. So he's let's just say he was a very naughty boy when he was younger, but found the Lord a few years ago. It has been redeemed. And got on last couple of days ago, almost tearfully, saying how upset and how horrific it was, and how empty he feels about this Charlie Kirk, or whatever his name is. I'd never heard of his name until he got shot. B, my brother apparently listens to one of his speeches every morning to motivate him. And this is where our worlds collide. Charlie Kirk. And then I find out that apparently Charlie Kirk is a Trump supporter, yes? Is that right? So that means my brother is against what? Homosexuality, transgender, the whole kit caboodle. Is that because I don't do politics, so I don't know the full thing, but that's apparently what I've heard. Yeah. Fuck me. So he's up in tears and feeling all empty, but he won't help his own mother. Bit too close to home, maybe. Bit too close to home. But you know, Charlie Kirk was apparently, according to him, he had the guts to stand up for human rights, basic human rights of all humanity. Isn't that what I was doing for my mum? Maybe. Just saying, you know. Just put it out there. But what would I fucking know? Yes, I don't do politics or religion at all. Oh, yes. Yep. And so he'll happily listen to his, and he only got on Facebook to try and prove to his congregation how dedicated he is. You know? Whatever. Has he ever offered to come and give his disabled sister a hand with anything? No, bollocks, yes.
Types of
Fucking
harms that are
hypocrites, a lot
alleged
of
in the
them.
complaint. So what we're
They
asking
can
the
all
court to do is
fuck
to
off.
dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
Thank you. So let's turn to the other defendants. If they want to be heard, you file separate motions, essentially arguing the same relief. But if you have anything you want to add, you certainly can.
No,
Waterfall.
Yes, Your Honor. Yeah, Waterfall, just very briefly. I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger.
True, and the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank
Yes,
you.
I agree.
The question that's really posed for this court.
I think that Charlie Kirk's biggest responsibility was as his father and a husband. That's where it ends for me. I don't give a shit what he did for them. He didn't deserve to die, regardless of what his belief system is or anything like that. So for me, politics and religion doesn't even come into it. It's basic human rights. Basic, simple as that. It's like, you know, everyone deserves a fair trial. But you'll have to wait for that one because that's coming. That's coming. Don't you worry.
Is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss the lowest standard. The Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden. So long as the court looks at the allegations holistically, if relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward. In this case, we pose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary right-line test.
What does NIED stand for again? Not. It's on the tip of my tongue and I can't remember it. NIED.
For such cases. Number three, Your Honor, The defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today.
Now, this is what gives me the shit.
Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and
Not that
nephew.
bit.
JJ no
The
longer has a
allegations.
voice. His life was wrongfully taken on January 29th, 2022.
Not by
He
Karen.
lived a life of service. He was a Boston police officer, and his personal life,
Yep.
when
and
JJ's
served
older
more.
sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them.
That's not disputed.
Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the
See?
cold.
How can you make that claim when she's been acquitted from that? Like, what the fuck? How can you make that assertion? A jury have found her not guilty.
And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she
Yeah.
returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life.
Yeah.
She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow. 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Semino case, where, let me just point out first, the wrongful death statute, it has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Semino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for overserving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress as a concept has evolved in the Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It direct.
All right, have a look at this. Ooh. Up you go. All right, this is the Massachusetts wrongful death statute. Let's make it a bit bigger, shall we? All right, I'll take those off the stage. Let's have a read. Get off. Get off. Thank you. Okay. Oh. No, thank you. Losing a loved one due to the negligence or misconduct of another party is a devastating experience. In Massachusetts, wrongful death. Do I get rid of that? Get rid of it. Oh, bye-bye. Their claims provide a legal avenue for surviving family members to seek justice and compensation for their loss. As compassionate personal injury lawyer, what constitutes a wrongful death in Massachusetts? Wrongful death occurs when a person's death is caused by the negligent, reckless, or intentional actions of another party. So she was charged with a DUI. So it's negligent, reckless, or intentional actions of another party. Okay, yep. She might have been reckless and negligent by drinking, but the death did not occur at the hands of that party. So I don't know how they do the two. Common scenarios leading to wrongful death claims include car accidents. Yep. If there actually was a vehicle pedestrian strike, yes. But it's been proven not. So it's filed for the benefit of the surviving family members of the deceased and hold the responsible party accountable. As far as I can see, the only person that might be liable, or people might be liable in this case, is the bars for the responsible service of alcohol, but I don't know how they connect. I don't get it. So, only certain individuals are eligible to file for a wrongful death claim. Only the state personal representatives, a claim for the surviving spouse, children, parents, or the deceased. It's important to consider an experienced person. Yeah, okay. Damages in wrongful death cases aim to compensate the surviving family members for the losses they have suffered due to the untimely death. Medical expenses, funeral and burial expenses, loss of financial support, loss of consortium, pain and suffering. Yep, no worries. Typical wrongful death cases. Consider a scenario where a pedestrian is struck and killed by a distracted driver while crossing the street. Oh. I wonder if this might apply to Australian law with my my friend's daughter. Wow. I might have to look that up. Not that you could ever put a dollar figure on a life, but I'm not sure. Oh, it's only you here anyway. Tricia, you know the details, so that's interesting. In another example, imagine a patient who dies as a result of medical negligence during surgery. Surviving family members may pursue a wrongful death claim. Against a negligent healthcare provider seeking compensation for medical expenses. Yeah, fair enough. I get all that. I understand it completely, and they have every right to do it. But I didn't think you could do it when you've actually been found not guilty in a court of law. because there is no double jeopardy. None. She can't be tried again for it. What's comparative negligence? Looking dangers of slip and fall accidents. Or maybe push and fall accidents. Do you guys have to pay a certain amount of your car registration that pays for like transport accidents and stuff? If anyone, like over here, we have to pay with the car rego. That there's a component to it. It's called TAC. It's the Transport Accident Commission. So if you've got that paid, I'll give you an example. It's not a nice one, sorry. My ex-husband, his mum died from cancer when she was 44, and his dad remarried. The woman he remarried had 2 daughters in their late teens. They went on, obviously, to grow up, and the eldest daughter had a baby. The baby, she got postnatal depression, and was actually in self-deleting watch, and had moved back with my ex-husband's father and his wife. And she managed to, when her mother was in the shower, sneak out of the house and run, I think it was about 300 meters away from a train line, and self-deleted. Now, because that was a transport accident that involved public transport in Victoria, and I don't begrudge her, but that baby, who is now, 23, 24, I think, never had to pay any school fees, like she was set for life, basically, in anything because of that insurance. So what do you pay emergency taxes, school taxes, and library taxes? So with your, how you have to have your license and then your registration, is there nothing under that registration that is like an insurance component for accidents and stuff? Or is that just for repair? It's not for like indemnity insurance in case you injure someone or, heaven forbid, kill someone. Because that's all covered in our oh, there you go. Have a look. Appreciate my backdrop. Yep. Had sometimes a change is as good as a holiday. Yeah. Oh, I didn't get a holiday, so. Now, I found some body cam footage, and I just found it really interesting to watch. It's actually when there's one from there's one from obviously the day of the 1st of February when Karen was arrested, and then there's one where back in June when she was arrested again. So I might try and I'll just show you a little bit of it. I think it's now that we've gone full circle, we know the whole kit and caboodle. I found this really interesting to watch. Let's share screen, shall we, Jodie? Come on, you can do it. And I think I do have it sped up too. No, but I will. Close captions and add to stage. Oh, really? Oops. Oh dear. Cats will do that, you know. That's instinctive. Oops. Bugger. And the bird's, it's tamed, obviously, so it doesn't have the fear of the cat either, obviously. Bugger. Does that just happen now, Peter Heff, or is that, have you taken the bird already? We put bells on the collars of the cats. You fell off the couch. Sorry. You really fell off the couch. A bird fell off the couch. Can he not fly? Oh, I suppose you probably clipped his wings. Oh. I hope he's okay. Bugger. Yes, please let us know. Speaking of cats, hello. They're confused because I've moved everything around there. Their treat bowl isn't right across my keyboard anymore. They don't have to walk right in front of me to get to it. I've put it out the way. Good luck, Odette. All right.
And then if you want, you can have more to it, and then we'll just put it on the video anyway. I mean, whatever works for you.
No, regardless. Over there, I just, you know what I mean? For the mileage wise, I was like, oh, I didn't want to start the call. I want to start doing it.
Aww. I've got those, you know, the round molded, they're sort of like buckets, but I use it as a laundry basket, and they've sort of got the molded handles with them, so it's all one piece of molded plastic rubber. I put marbles in the bottom of it, and my cats love it because they spin it around. Something so simple.
One of these. Okay. All right. See you. Sure. Do you want to step in here?
Now, do you remember who it was? Do you remember who the arresting officers were? Is that Garino? Is it Garino? I might have to dig the database out. Oh, I actually packed all of my Karen Reid notes and documents and stuff away on the weekend. That was very sad. Now I need to look at them. I wonder who is the arresting? Face is familiar. I wonder if it's got anything in there.
I'm just going to take the coat off and give that. We can't do regular. Do you have anything in your pockets or anything like that?
No.
Are you? I mean, you want to just look straight ahead at the camera for me? Just sit chin down a little bit. Just gonna click a couple times so keep looking at it. See your right hand, correct? Yes.
24 for me. You want to talk to him real quick?
left hand or something?
I'm sorry, my left?
Right hand side, my apologies. Okay, sure.
You all right? So we just gotta go through some standard booking questions, okay?
We get Miranda's or? Yeah. Is it in the booking thing that you have to read it again? I remember when I was in the. Miranda's. Yeah, so you did over there, but if you want to do it again, you can do that. So you can do it. Just do it. We're not gonna question. Yeah, no. So she can refuse to sign it. Yeah, if she wants to sign it, she can sign it if you want to. So Karen, again, real quick. We went through it. You ready to make sound? Anything you say can be used against you in court. You ready to talk to a lawyer for advice before you ask him any questions, and you have to have her with you a question. If you cannot afford a lawyer, one will be appointed for you. If you decide to answer questions now, you still have the right to stop questioning at any time. Do you understand what I meant to? Okay. So that's how we do it by the books. If you sign it, you can sign it. If you don't want to sign it, you don't have to sign it.
I'm just signing that I understand what you said.
Yeah, you were right.
Okay. Can I check these boxes? Can I check no?
You can check no.
What track number?
410.
It's the first.
February, it's 8/16.
Zone. Thank you.
And you have any injuries to your wrist?
No.
Okay, you take any medications? Should we have those with us?
I usually individual and stuff for crimes to take. She doesn't have a copy, right?
No, they have a cell phone. Keep this, your phone, your mom's phone.
My mom's.
Your mom's phone. Jackie.
Do you have a medication?
We have a medication, yeah.
And my license?
Karen, do you have your attorney's number?
Yes.
Oh, you do, okay. I called him, I left a message. You guys are coming back. But you have it, if you want to call him here.
Okay.
No, do you?
Yeah. Can I?
Yeah, oh, yeah,
Yeah.
oh, absolutely. You're gonna get a call as soon as it's done?
Okay.
Do you have the actual number though?
Mm-hmm.
You have it memorized? It's in your phone.
I have it memorized.
Okay.
What is your phone number? Where were you?
Stowing.
This one's like what's not, I tried to oh, there. Yeah.
Doesn't say.
Not even in there, is it?
About how tall are you?
5'6".
So how much do you weigh?
115.
Your hair color?
Brown.
Eye color?
Brown.
All right, can I other side? Yep, you're okay.
It's such a degrading process.
You can have a seat if you feel more comfortable.
And then there was
Remember Miranda and citation again?
oh, this one.
So we're gonna get up. I'm gonna have you check your property checklist. You see if everything's there. You're gonna sign for it now. Then we're gonna do your fingerprints. Okay.
Okay. What's your last name?
Read.
Goodness, read. If you want, you can secure and.
All right, so this is after she was indicted by the grand jury, and this is when Proctor and Buchanan went to pick her up from her parents' house.
Okay, we can do that. I put you in as a backup. I remember the primary was.
Okay, yeah, it's gonna be one of them, I believe.
Sure.
Just have a seat right here.
Can I put pants on?
Yep, in a second. Just have a seat right here for me, okay? Slide over here a little. Slide over a little more.
That's right. She had her period, and they wouldn't let her get changed, and they arrested her.
This is all your possessions, right? Phone, the medication, the pants, the cell phone, okay?
And our box.
There's all that stuff, okay. I did.
You did?
Yeah. Yeah, I did. Thank you.
That's Buchanan you can hear in the background. Bukaki.
So are these yours or his?
That's
Is it?
Where do they plug these in around here?
In the desk somewhere, I believe, right there. Thank you, sir.
I'll set up a camera.
Beautiful, thank you.
See if you need more. They're right there.
Somewhere.
Over there. We got all sorts of markers if you need to write anything.
Okay, thank you.
Yep.
So is that Proctor? Is that his body cam? There it is.
Yeah, no problem.
No, there's Proctor there, I think. Is that Proctor?
Yeah.
Yeah.
4378.
4378.
Ah, this is Justin Pye, sorry. It's only down in the bottom right-hand corner. So, Proctor and Buchanan are the ones coming in and out that left door. They're wearing that uniform.
Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure he'll go over the charges again with you on the morning.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ramsey.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges that you were arrested on initially were out of district court, Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving scene of death. Okay, so those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in death. Okay.
So bail doesn't apply anymore?
Typically, I'm not. So we don't set a bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges you're being charged with now, and you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Colin Albert.
You're aware he was beaten up. Have a listen to that.
Okay, so that's the charges you're being charged with now, and you were indicted by grand jury.
Okay, you're aware he was beaten
You were
up by
aware
Brian Colin Albert.
he was beaten up by Brian and Colin Albert. Let's hear it again, shall we? Because, you know, one doesn't get sick of hearing that.
That's correct. It's a higher degree of taking a life. Okay, so that's the charges you're being charged with now, and you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you. Okay, so you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you're ready to your rights, okay? And I'm sure he's gonna do it again. All right. If you want to talk to us, you want to give us a story, definitely. We'll take it.
I know you already know the story, so I don't need to. So I can make that phone call after.
After your vote, absolutely.
And can I get a number out of my phone?
Absolutely. You've been treated nothing, short of with respect the last time. You'll be treated the same way. I tell every individual that I interact with in this capacity, you act like a gentleman or a lady, you can be treated like one. Okay? You haven't given us a reason to not mistreat you, but take a harsh ride with you. So we're going to treat you just like we would anybody else in your position. Okay? So we're going to be respectful and professional. All right? We just want the same respect back. Okay?
That's funny. Okay? I didn't know you had a sense of humor. What a fucking joke. Needs on the phone. That's respectful.
I couldn't take it. So you got the prescription, so you got your phone as well. Okay?
Ready, 1, 2, 3.
Lovely photo. Oh my god.
All right, all set. You have a seat again.
Imagine what's going through her head. Just imagine, like, what the fuck? So she's already out on $60,000 bail. Court. And now she's been indicted of a grand jury. And they just quit.
True, statewide.
Great.
So 15 minutes, we'll see if it's working. That's my instructions for my yes, we'll see if it's working in 15 minutes.
Yeah, I got nothing here, so.
Okay.
We'll do, we can get her a phone call, get that out of the way, I guess, and get the picture.
Yeah, and once this is working, get her book fingerprinted.
Yeah.
But that'll go, once it's up working, it'll be quick.
Yeah, no, I get it. You want to call your parents? You
No.
have the number on your phone?
No, I don't. I'm not right now.
Talk about that.
What's the number?
Dad? Can you hear me? Okay, so I'm in jail again. Because. Okay, what did you say? No, it's not, I don't really need anything, I don't even care at this point. I don't even have pants on right now, I don't even have shoes on. Nope. What I need, but, I mean, it doesn't even matter at this point, I just would like to brush my teeth. But, yeah, so David explained everything? It's, his name is, I can't think of it, Oliver. Richard, yeah. Yep. Yes. What did David say, Dad? Yeah, so because he explained it's not manslaughter anymore, that's why. All right, so you understand? Okay. So, no, don't even bother, don't even bother. I guess I'm gonna be arraigned in the morning, so you'll come to that, and it's too late to don't bother letting anybody else know, and I'm just gonna wear my pajamas that I have on. Yeah, yeah, if you can come, I mean, it doesn't even matter, you can come up and bring me a toothbrush in the morning, but it's not. Yeah, I don't want them, no, I don't want them, no, I don't, I'm sorry. Yeah, same. Yeah, listen, do I have in your house? And a toothbrush? Okay. Okay. Yeah, like now? Okay. And what else did David say? Okay. No, just you.
Yeah, on the email first. Thanks. Okay.
I don't have access to any of that. Yeah, I will. Listen to me. I don't know what's gonna happen after tomorrow, because I might be incarcerated after this, Dad. All right. Dad, in your email from tonight, the latest thing I sent you, send it everywhere. You understand? Send it everywhere. No, Dad, you understand? Okay, because I might back it out. All right, and I'm supposed to get social, by the way. Yeah, next Wednesday, yeah. Okay. Okay. All right, I don't know, you might wanna go to my house and get my wallet, and I can get it. For yes. I mean, after this, if that's granted, I don't wanna waste another day. Do you want my, password to send one or something? Yeah, but it may be like this going forward regardless. How I communicated with him. Yeah, you're gonna have to think about it. Yep. Actually. Yep. And all the police have heard that too now, so. But what I sent you tonight is revised, so use that one, okay? All right, and you just have Mom, if I need a toothbrush. Okay, all right, love you, Dad. Bye.
I wonder what was in that email.
Can I put those pants on?
Yeah.
All right, hang tight. I'm going to find this paperwork, and we will switch shortly to do Dr. Mellon. I'll be right back.
PYE. Not sure. Let's see if there's any progress.
You want the water or something?
No, thank you.
Are your parents coming? Should they expect them to arrive?
Yeah, they're a ways away.
Yep.
All right, I'll be 2 minutes. Just going to spend a penny. I'll be back.
So you're set? You're part of it? You're set because you're part of it? Yes. Confirm to us.
You don't know. You don't know. That's what you asked.
Okay. So you're gonna skip out tomorrow? Make it ready? Make it ready?
You know, you don't want those. Which is fine.
You can tell Kim's gonna go order some food for the night. That's listed in here, doesn't much. I'll have him locate that. Mike, do you mind say project number for go down to the best option for us and also provide Adam's number just in case? Thanks. First left.
Hold on one second. Keep the slippers on or off? Do you have socks on?
Mm-mm.
No?
Yeah, so if you take a look.
Nothing in them, right? Just take them off for me. You just put the pants on, nothing in the pockets at all? I gotta search you, okay? Yeah, can you pull the pockets out so I don't have to? Nothing in the pockets? Nothing in the waistband, anything? Nothing in the back pockets? Okay, and no pockets in the shirt? Okay, just the t-shirt underneath, right? That's it? All right, just can you take the necklace off?
All right, yeah. Okay. Enough of that. All right, so I've printed it all out. All right. Where's the start? All right, so this is a case out of Pennsylvania. I suppose I better switch over to the next stream that I have set up ready to port you over. Alrighty, hold tight because you're on for a ride. See you on the other side. Oh, hang on, let me open. I better open another tab for StreamYard so that I'm there ready and waiting. Otherwise, you'll be all lonely. You'll be there all by yourself. Enter studio. Okay, we don't want Karen Reid up there. I'll put that on. Okay. See you in the soup. See you on the other side.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests.
where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.